Evidence, Rule 133, Weight and Sufficiency of Evidence. Section 1, Preponderance of Evidence, how determined. In civil cases, the party having the burden of proof must establish his or her case by a preponderance of evidence. In determining where the preponderance or superior weight of evidence on the issues involved lies, the court may consider all the facts and circumstances of the case. The witnesses' manner of testifying, their intelligence, their means and opportunity of knowing the facts to which they are testifying, the nature of the facts to which they testify, the, the probability or improbability of their testimony, their interest or want of interest, and also their personal credibility so far as the same may legitimately appear upon the trial. The court may also consider the number of witnesses, though the preponderance is not necessary with the greater number. Section 2. Proof beyond reasonable doubt. In criminal cases, the accused is entitled to an acquittal unless his or her guilt is shown beyond reasonable doubt. Proof beyond reasonable doubt does not mean such a degree of proof as excluding possibility of error produces absolute certainty. Moral certainty only is required, or that degree of proof which produces conviction in an unprejudiced mind. Section 3. Extrajudicial confession, not sufficient ground for conviction. An extrajudicial confession made by an accused shall not be sufficient ground for conviction unless corroborated by evidence of corpus delicti. Section 4. Circumstantial evidence when sufficient. Circumstantial evidence is sufficient for conviction if A. There is more than one circumstance. B. The facts from which the inference are derived are proven. And C. The combination of all the circumstances is such as to produce a conviction beyond reasonable doubt. Inferences cannot be based on other inferences. Section 5. Weight to be given opinion of expert witness. How determined? In any case where the opinion of an expert witness is received in evidence, the court has the wide latitude of discretion in determining the weight to be given to such opinion, or for that purpose may consider the following. A. Whether the opinion is based upon sufficient facts or data. B. Whether it is a product of reliable principles and methods. C. Whether the witness has applied the principles and methods reliably to the facts of the case. And D. Such other factors as the court may deem helpful to make such determination. Section 6. Substantial evidence. In cases filed before the administrative or quasi-judicial bodies, a fact may be deemed established if it is supported by substantial evidence, or that amount or relevant evidence which a reasonable mind might accept as adequate to justify a conclusion. Section 7. Power of the court to stop further evidence. The court may stop the introduction of further testimony upon any particular point when the evidence upon it is already so full that more witnesses to the same point cannot be reasonably expected to be additionally persuasive. This power shall be exercised with caution. Section 8. Evidence on motion. When a motion is based on facts not appearing of record, the court may hear the matter on affidavits or depositions presented by the respective parties. But the court may direct that the matter be heard wholly or partly on oral testimony or depositions. Rule 134. Perpetuation of testimony. Section 1. Petition. A person who desires to perpetuate his own testimony or that of another person regarding any matter that may be cognizable in any of the Court of the Philippines may file a verified petition in the court of the province of the residence of the expected adverse party. Section 2. Contents of petition. The petition shall be entitled in the name of the petitioner and shall show A. The petitioner expect to be party to an action in a court of the Philippines but is presently unable to bring it or cause it to be brought. B. The subject matter of the expected action or his interest therein. C. C. The facts which he desires to establish by the proposed testimony and his reasons for desiring to perpetuate it. D. The names or a description of the person he expects will be adverse parties and their addresses so far as known. And E. The names and addresses of the persons to be examined and the substance of the testimony which he expects to elicit from each and shall ask for an order authorizing the petitioner to take the depositions of the person to be examined named in the petition for the purpose of perpetuating their testimony. Section 3. Notice and service. The petitioner shall thereafter serve a notice upon each person named in the petition as an expected adverse party, together with a copy of the petition, stating that the petitioner will apply to the court at a time and place named therein for the order described in the petition. At least 20 days before the date of hearing, the notice shall be served in the manner provided for service of summons. Section 4. Order of examination. If the court is satisfied that the perpetuation of the testimony may be prevent a failure or delay of justice, it shall make an order designating or describing the persons whose deposition may be taken and specifying the subject matter of the examination, and whether the depositions shall be taken upon oral examination or written interrogatories. The depositions may then be taken in accordance with Rule 424 before the hearing. Section 5. Reference to court. For the purpose of applying Rule 24 to depositions for perpetuating testimony, each reference therein to the court in which the action is pending shall be deemed to refer to the court in which the petition for such deposition was filed. Section 6. Use of deposition. If a deposition to perpetuate testimony is taken under this rule, or if, although not so taken, it would be admissible in evidence, it may be used in any action involving the same subject matter subsequently brought in accordance with the provisions of Section 4 and 5 of Rule 24. Section 7. Deposition pending appeal. If an appeal has been taken from a judgment of the regional trial court or before the taking of an appeal, if the time thereof has not expired, the regional trial court in which the judgment was rendered may allow the taking of depositions of witnesses to perpetuate their testimony for use in the event of further proceedings in the said court. In such case, the party who desires to perpetuate the testimony may make a motion in the said regional trial court for leave to take the depositions upon the same notice and service thereof as if the action was pending therein. The motion shall show a. The names and addresses of the persons to be examined and the substance of the testimony which he expects to elicit from each, and b. The reason for the perpetuating their testimony. If the court finds that the perpetuation of the testimony is proper to avoid a failure or delay of justice, it may make an order allowing the depositions to be taken. And thereupon, the depositions may be taken and used in the same manner and under the same conditions as are prescribed in these rules for depositions taken in actions pending in the regional trial court.